Hello everyone and welcome to the May 2024 episode of My PIP Monthly. As always, my name is Amber Rouse Holloway and I'm an executive partner here at our Troy office. This month I'll be joined by Nick Ackerman, an associate attorney of our Troy office. Our May 2024 topics include, of course, a case law update. I'll be talking about two recent unpublished opinions of the Court of Appeals. First up is the case of Estate of McDuffie Connor v. Neal and NSS Construction. And then we'll move on to Christensen v. Amazon Logistics. Again, both of those are unpublished opinions of the Court of Appeals. And then moving on to trending topics in PIP litigation, Nick will be discussing Moda Pergoop v. Falls Lake National Insurance Company. And that's a current case pending in the Court of Appeals. And to follow up with that, he'll be discussing some issues surrounding the innocent third parties. And for our case law update, we have the first case, which is going to be Estate of McDuffie Connor v. Neal and NSS Construction. Now, this case centers around an allegation of spoliation, which is proper where evidence spoliated is 1, material, 2, not merely cumulative, and 3, not equally available to the opposite party. A party has a duty to preserve evidence material to litigation that is pending or that is reasonably foreseeable. And sanctions, once spoliation is determined to have occurred, must be proportional and are proper if the court carefully fashions a sanction that denies the party the fruits of the party's misconduct, but that does not interfere with the party's right to produce other relevant evidence. Now here, the relevant facts are that the decedent was killed in a motor vehicle accident on July 17, 2019, where he tried to pass a dump truck driven by defendant Neal. Defendant Neal put on his blinker and turned right, and the decedent smashed into the front passenger side of the dump truck, causing the decedent's vehicle to flip over the front of the dump truck, and he was unfortunately killed. The personal representative of the decedent of plaintiff's estate sued defendant driver Neal and Neal's employer, who was NSS Construction, for negligence, wrongful death, vicarious liability, among some other counts. Now, after the accident, but before the lawsuit was filed, the decedent's car was sold from the police impound lot because plaintiff failed to pick up the vehicle after some time. Additionally, defendant NSS's business was subsequently closed due to an unrelated foreclosure, and numerous business documents were destroyed. And during litigation, plaintiff sought sanctions against defendant NSS based on the failure to produce several of the destroyed documents, including Neal's driving and employment records and the dump truck's maintenance and inspection records. Now, ultimately, the trial court here imposed sanctions on defendant NSS and held that it spoliated evidence by not producing the destroyed documents. The trial court denied the defendant's requested relief regarding plaintiff spoliation, though. Now, NSS did appeal to the Court of Appeals, challenging the trial court's order, granting plaintiffs relief regarding spoliation, but denying NSS's relief regarding the plaintiff's own spoliation. On appeal, the Court of Appeals held that the trial court abused its discretion by granting plaintiff's motion regarding defendant's spoliation and sanctioning defendant while simultaneously denying defendant's motion requesting similar relief. Now, the Court of Appeals held that the trial court did indeed abuse its discretion by sanctioning defendant for spoliation because 1, the evidence was not material to the plaintiff's lawsuit, 2, litigation was not foreseeable, and 3, the sanctions imposed by the trial court were disproportionate to the claim. The court went on to explain that plaintiff's claims of spoliation were flawed because the evidence that plaintiff claimed was spoliated was not material to the relevant elements in the case. Now, this case provides points to consider when a claim of spoliation is made or considered. First, a party has a duty to preserve evidence material to litigation that is pending or that is reasonably foreseeable. Second, an allegation of spoliation is proper when the evidence spoliated is 1, material, 2, not merely cumulative, and 3, not equally available to the opposite party. And third, once spoliation is determined to have occurred, sanctions must be proportional and are proper if the court carefully fashions the sanction that denies the parties the fruits of the party's misconduct, but does not interfere with the party's right to produce other relevant evidence. Next up, we have the case of Christensen v. Amazon Logistics, again an unpublished opinion of the Court of Appeals. This one was issued fairly recently in April of 2024, but this case highlights the importance of proffering direct, substantive, admissible evidence that shows no question of material fact for summary disposition brought under MCR 2.116C10. Now, here it's important to note that the production of expert opinion reports should be done prior to the close of discovery. Now, the plaintiffs here were involved in a motor vehicle accident on October 31st, 2020, in which they were rear-ended by a semi-truck that they alleged was being operated and driven by defendant Hussein Afraf and owned by defendants Sarajevo and EMB Enterprises. Now, here, Amazon timely filed its motion for summary disposition. It was a C-10 motion, and plaintiff filed a response on September 1st, 2022, which argued that plaintiffs had sustained threshold injuries and serious impairments of an important bodily function. And obviously the defendant here argued the opposite. Now, attached to their response, plaintiff highlighted and attached 300 pages of medical records without an appendix or notations. Amazon in turn filed its reply brief, arguing that the plaintiffs had conceded summary disposition on plaintiff's claim that the plaintiff had not demonstrated an objectively manifested impairment that prevented him from living his normal life, and none of the plaintiffs could demonstrate entitlement to their excess wage loss claim. Now, oral argument here on these MSDs was heard on October 6, 2022, and ultimately the trial court did grant Amazon's motion and disposed of plaintiff's claims. Now, plaintiffs thereafter filed a motion to set aside or clarify the order regarding summary disposition in favor of Amazon, and they also sought relief from the judgment and or reconsideration of the order. Amazon argued that plaintiffs were improperly submitting affidavits and expert opinions to the court that had been produced months after the close of discovery. Now, here in their motion to set aside and their motion for reconsideration, plaintiff added expert reports that said that the plaintiff was injured, did sustain a bodily injury that affected her everyday life. But it was the first time that Amazon was ever notified of this document or ever received this document. Now, in discussing Amazon's motion for summary disposition, the Court of Appeals held that Amazon identified the matters that had no disputed factual issues. It was then incumbent on the plaintiffs to establish by evidentiary materials that the question of material fact existed, and therefore the trial court could not be precluded from granting, the trial court was precluded from granting Amazon's motion for summary disposition. So here, Amazon's initial motion argued that plaintiff had not sustained an important bodily injury, and plaintiff did nothing to refute it. They attached 300 pages of medical records, but the court said that that wasn't enough, and therefore they disposed of the case. Now here, to get a second bite of the apple, plaintiff produced those expert reports that said that plaintiff was injured. Now, the trial court had to consider evidence that was admissible, that plaintiffs proffered in opposition to the motion, not the plaintiff's arguments. The plaintiffs bore the obligation to direct the court to the evidence that established a question of fact, and ultimately the trial court said that the plaintiff did not do so at the time. Now, to the extent that plaintiffs sustained a threshold injury under the No Fault Act because they had closed head injuries, the plaintiffs failed to rebut Amazon's motion for summary disposition by only attaching medical records, which did not constitute testimony under oath as required by MCL 500-3135, Section 2. Further, the records were only for plaintiff Joseph Christensen and not plaintiff KLC, so the records could not support any claim for the other plaintiff or KLC. Now, the Court of Appeals took further exception to the trial court allowing new evidence, the medical records and affidavits that were not previously used in the plaintiff's response. But the trial court did fail to cite any court rule or precedent to grant the extraordinary relief it provided to the plaintiffs, which in the use of undisclosed expert reports and records that had not been produced during discovery and produced only a month before a trial on a case that had been pending for 18 months here. This was not new evidence, and the court could not allow for the relief the trial court provided to plaintiffs.
Thank you again, Amber, for allowing me to participate in today's trending topics when discussing PIP litigation. My name is Nicholas Ackerman. I'm an associate attorney here at Seacrest & Wardle, and today we will be discussing the curious case of Montpelier versus Falls Lake National Insurance Company. That is a Court of Appeal decision as of March 28, 2024. In this particular matter, the plaintiff was involved in an accident. Prior to the date of loss, the court took issue, or at least defendant did, surely, as to the plaintiff stating that she had no dependent children living with her at the time the accident, and that she had no plans to drive for a ride-sharing purpose at the time of the procurement of the policy. Based on these two alleged material misrepresentations, defendant Falls Lake filed its motion for summary disposition against plaintiff, but also against intervening plaintiff, that being Spine Specialist, the alleged medical provider. So notably, at the lower court level, the trial court did describe this case as fraud in the procurement of an automobile insurance policy. Ultimately, defendant was in fact excused from this respective matter. Further, intervening plaintiff's claim was also dismissed as being a derivative claim of plaintiff's complaint. Now, on appeal, the intervening plaintiff argued that the record before the trial court does not contain evidence demonstrating the materiality of plaintiff's misrepresentation. Second, and more importantly to today's conversation, defendant's right to rescind plaintiff's policy does not automatically defeat the medical provider's claim as a healthcare provider under MCO 531.12. Now, the emphasis is going to be placed on the word automatically, as the Court of Appeals took issue. Now, distinguishable from prior established law, it must be understood that simply filing an MSD as to a medical provider will not simply defeat such a claim without first analyzing now the medical provider's claim, plaintiff or intervening plaintiff, from the lens of an innocent third party. In other words, now the court's going to appear to be interested in the application of innocent third parties as they pertain to medical providers, not necessarily either the plaintiff or the underlying claimant. Now, although the primary focus on the above referenced matter, it's important as a reminder that all elements needed to establish a material representation must be addressed, as plaintiff was not found committing material misrepresentation when not disclosing her dependent as resident during the procurement of the policy. However, it was established that plaintiff's false representation of not utilizing the involved vehicle for ride-sharing purposes is entitled defendant to summary disposition. Now, again, the issue, though, before the Court of Appeals pertained to the effect of rescission upon the claims the healthcare provider. So pre-reform, it's understood under the seminal case Covenant, they permitted medical providers to file claims against auto carriers exclusively through an assignment of claims. This will give the medical provider standing in the first place. Now, post-reform, however, the Court of Appeals holds that the legislature subsequently altered the MCO 531.12, and those providers are permitted to pursue claims in their own right, i.e., can still establish standing without necessarily having that executed assignment of rights. Now, as it pertains to this case with the Court of Appeals, that statutory amendment renders inoperative the trial court's characterization of Spine Specialist's claim as derivative in this case. More specifically, as medical providers no longer require an assignment of rights to make a claim but now possess a direct cause of action against the carrier, the newly amended MCO 531.12 no longer requires that providers must stand in the shoes of an injured person to pursue no-fault claims. And thus, if medical providers' claims is no longer derivative of the underlying claim, nor necessarily even foreclosed by rescission of the insurance policy that an insurer issues to an insured. So, when addressing a medical provider's interest in a claim other than fraudulently insured, the Michigan Court of Appeals harkened back to the Michigan Supreme Court precedent, namely, just as the intervening interest of an innocent third party does not altogether bar rescission as an equitable remedy, neither does fraud in the application for insurance imbue an insurer with an absolute right to rescission of the policy with respect to third parties, which brings us to the matter of Bozzi. As people familiar with Bozzi, we've grown accustomed to consider in PIP-related matters, it is held that when two equally innocent parties are affected, the court is required in the exercise of its equitable powers to determine which blameless party should assume the loss. Well, post-Medipurger, this line of reasoning is now shifting heavily more toward protecting medical providers from actions solely conducted by insureds. Again, now we're looking as to that application of the innocent third-party doctrine as it pertains to medical providers, not just the person who took out the claim itself or the policy itself. The Michigan Court of Appeals also addressed C-spine orthopedics, wherein the court reinforced that a provider's interests were not properly litigated where the trial court granted rescission, after dealing with only the insured's claim while not simultaneously considering the provider's interests when deciding whether rescission is equitable. In other words, when an insurer or insurance carrier is faced with a direct claim by a provider, the trial court has an obligation to balance the equities of rescission and therefore can err, as the trial court did in this respective case, when it automatically dismisses a provider's claim based on the insured's material misrepresentation. As with claims pertaining directly with insureds, attorneys representing insurance carriers must ensure that the trial court judges review and apply applicable Bozzi factors regarding innocent third-party doctrine to medical providers, both via brief as well as oral argument. And it's a good habit to continue, as obviously the Court of Appeals, as in this respective case shows, they take great interest as to whether or not the Bowsley factors were considered. So where do we go from here? Well, unfortunately, the Court of Appeals has left the trial court and the MI PIP case to further flesh out factors considered when textualizing disputes between insurer and healthcare providers. As such, applicable factors in Bowsley ought to remain at the forefront of legal representation of insurance carriers, along with the factors that may pretend to show a medical provider actively engaging in a shape or form of fraud and or material misrepresentation, or perhaps a lack of due diligence, while maintaining a claim on behalf of the insured or underlying claimant. Until then, the application of an innocent third-party doctrine as to medical providers ought to remain a focus for insurance carriers, as the legal landscape regarding an otherwise settled area of practice is beginning to change for better or worse.
And that is all we have for you guys today. As always, thank you for attending the May 2024 episode of MI PIP Monthly. My name is Amber Rouse Holloway, and of course we welcome any questions and or concerns you guys might have for myself or Nick.